Section 61 of the Australian Constitution says that the executive powers are vested in the Queen and exercised by the Governor-General. But what are these powers? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look at the different types of executive power. We can roughly divide the executive powers into two major groups, the constitutional and statutory powers and the non-statutory powers. So in this video, I will talk about the specific types of power within each one of these groups. By the way, if you want to be notified when I upload my next video, make sure you subscribe to our channel and you also hit the bell sign. The first type of executive power is the constitutional power. These are the powers that are laid out by the text of the Australian Constitution. For example, if you open Section 64 of the Australian Constitution, you will see provisions about the appointment of Ministers of State. If you look at Section 68, it refers to the command of naval and military forces, which are also part of the executive. Also, Section 70 refers certain powers that once belonged to the governors of the states, now to be exercised by the Commonwealth Governor-General. So yeah, there are some other provisions in Chapter 2 of the Constitution that also relate to types of powers that can be exercised by the executive. Now, it's also possible for Parliament to give powers to the executive. It's the same thing as if the executive was receiving powers from the Constitution, but instead of the Constitution, the powers are granted by an Act of Parliament. These are called statutory powers, powers that are given by Parliament via the enactment of statutes to the executive. Also, there's the possibility of the executive receiving delegated legislative powers. But this is another story, and we've already talked about it in another video. So, at first, there are certain powers that are given either by the Constitution or by Acts of Parliament. But this is not all. There's another category of executive powers, and these are called the non-statutory powers. What are they? These are powers that are not expressed in an Act of Parliament or in the Constitution. They relate to some powers, immunities and privileges that the Crown has acquired throughout history. Broadly speaking, we can refer to four types of non-statutory powers: reserve powers, prerogative powers, nationhood powers, and the common law capacities of the Crown. Reserve powers have been mentioned already in this channel. These relate more to the formal repository of the executive powers, that is, the Governor-General, in its relationship with Parliament. So it is something related as well to the principle of responsible government. For example, the reserve powers relate to the appointment or the dismissal of a Prime Minister, the decision or refusal to dissolve the House of Representatives, or the application of mechanisms to hold the executive into account. The other type are the prerogative powers. These are quite extensive and, in a sense, very hard to define. But these relate to the traditional prerogatives, that is, the historic powers, immunities, privileges that the Crown has enjoyed. That's why some people even call the non-statutory powers prerogative powers, just to put everything into that context. But specifically here, when we're dealing with prerogative powers, we're talking about those powers that are usually given to a head of state, like declaring war and making peace, entering into international treaties, and even granting of royal pardons. But they can also relate to protections and immunities that the Crown usually has, like immunity from prosecution, or, as we discussed in the case called Siga-Matic, a priority as a creditor. So all in all, these prerogative powers, they relate to these powers and priorities that are given to the Crown or exercised by the head of state. An interesting characteristic of the prerogative powers is that neither the Crown nor Parliament can create new prerogatives. That's right. Prerogative powers are the powers that already exist and are exercised under the common law by the Crown in right of states or the Crown in right of the Commonwealth. Some consider the nationhood powers as part of these broader prerogative powers, but I think it's good to separate them for learning purposes. Nationhood powers are the non-statutory powers that relate to that expression in Section 61 of the Australian Constitution, the execution and the maintenance of the laws of the Commonwealth. A good example is the exercise of powers that relate to the celebration of important dates, like what was confirmed by the High Court in a case called Davis and Commonwealth of 1988 in relation to the bicentenary of the Commonwealth. So, these are executive powers that can be exercised by the Federal Commonwealth in relation to significant celebrations, symbols that relate to the national character of Australia, the identity of Australia as a nation, and even to the protection of borders and coercive measures that are necessary to keep the borders safe. Ultimately, they relate to the notion of Australia as a sovereign nation. This was recognized in a case called Ruddock Vadalis in 2001. This case is also known as the Tampa case, but we will talk about it in another video. By the way, if you're liking this video so far, let me know by clicking the like button. Finally, the last type of non-statutory executive powers are called the common law capacities of the Crown. You see, generally speaking, the executive will also have the capacity to do some things like if they were a normal person. They have the legal personality to enter into contracts, buy and sell things, spend money generally. It's the sort of powers that a normal human would have. So they relate to certain capacities that the Crown has, just like us. And since we are talking about the possibility of the Commonwealth spending money, I would suggest you to click the subscribe button and enable notifications, because my next videos will bring some information about appropriation bills and some constitutional cases related to the possibility of government expenditure. You don't want to miss them. Thanks for watching. It's such a privilege for me to be here teaching you about Australian constitutional law. If you like these videos, don't forget to click the like button, but also comment and keep on giving me feedback, because I can make these videos better for you. Again, thanks for coming, thanks for watching, to staying until the end, and I hope to see you next time. Until then, ciao.